Hi, I'm Kiza Cunha, and this is my presentation of the case between Ranch L.L.C and Taco Bell Corporation of the infringement of a marketing concept. These are the facts and what we know about the case. The plaintiffs Thomas Rinks and Joseph Shields from Ranch L.L.C are from Grand Rapids, Michigan. Taco Bell is a restaurant franchisor brand focused in Mexican cuisine with its principal offices in Irvine, California. The dispute started because Rinks and Shields from Ranch believed that Taco Bell used a copyright concept the plaintiffs were trying to sell to the defendant. In 1995, the plaintiffs created a Chihuahua cartoon character named Psycho Chihuahua, supposedly a feisty, edgy, and confident dog with a big dog attitude. Taco Bell ran an advertising with an animation of a female Chihuahua named Gidget, which was different than the plaintiff's version. Ranch sued Taco Bell for allegedly using plaintiff's idea to create the brand's own Chihuahua character instead of purchasing the rights to the existing one. The legal analysis of these issues. So the plaintiff sued Taco Bell claiming that they had breached an implied in fact contract, which means when a party requests another party to disclose an idea and understands that the other party discloses it with an expectation for compensation for the use of that idea, an implied in fact contract is created. I apologize for noise that might be happening outside of this presentation. I am recording it inside my car, which is closed, but there's people on the outside that might be making noise. Back to the presentation, plaintiff created the Psycho Chihuahua. Employees of Taco Bell creative department saw it at a trade show and talked to plaintiff to use it in retail licensing. The plaintiff hired a licensing agent in order to draft an agreement to use with Taco Bell. The discussion then talked about advertising. The plaintiff's licensing agent sent a proposal to defendant to use the Chihuahua character. The proposal asked Taco Bell to pay plaintiff a percentage of the expenses in advertising, retail licensing sales, and the cost of items such as Chihuahua toys that would be sold at Taco Bell. The proposal was ignored, but the conversations between the parties kept going. What happens next? Defendant asked plaintiff to create a presentation for the marketing department, which included hats they made, merch they made for Taco Bell, but the presentation never occurred. The creative department of Taco Bell still wanted to use the character. Defendant then hired a new agency that created a commercial for a car company with a driving Chihuahua. The materials of Psycho Chihuahua were delivered by plaintiff to the marketing department of Taco Bell. Those were then sent to the new agency who created a commercial for Taco Bell showing a Chihuahua choosing Taco Bell's food over a female Chihuahua. That was the idea that Ranch had originally given to defendant. In a few months, Taco Bell aired commercials showing a Chihuahua saying, "Yo quiero Taco Bell." The commercials were successful, and Taco Bell still uses the character. Plaintiff sued defendant for breach of implied in fact contract, misappropriation, conversion, and unfair competition. So then the decision of the court. Here's when the defendant moved for summary judgment on all claims and argued that there was no implied in fact contract and that the Chihuahua idea came from the new agency and not from the plaintiff's idea that were not novel. Plaintiff then appealed to the grant of summary judgment, and the Sixth Circuit reversed, finding the contract claim was not preempted by the Federal Copyright Act. And in 2003, plaintiff was awarded over $30 million in damages from a jury. A similar case that happened between Lapine and Seinfeld in the New York court was that Missy Chase Lapine, the plaintiff, sued the defendant, HarperCollins Publishers, for breach of implied contract for using her ideas without compensating her for them, and unfair competition. HarperCollins moves to dismiss all claims. Then, Lapine argues that her submission of the Lapine's book proposal was sent with the understanding of reasonable compensation by HarperCollins, and if made use of Lapine's book manuscript, ideas, recipes, or other matter, she should be compensated. The court notes that nearly 2 years passed between plaintiff's submission of her proposal to HarperCollins and its publications of the new book. And even if time had not been an issue of relevance, the question is not whether the defendant may have used plaintiff's idea, but whether plaintiff had an enforceable property right in that idea. The court decided then that plaintiff did not have such a right, and given the lack of novelty of her idea, as well as her failure to plead a fiduciary or contractual relationship with the defendant, she her case was dismissed. Questions and considerations. Here, should artists or creatives be protected in case a big corporation steals or copies a concept brought to them as a possibility of collaboration, which would include compensation? Or should there have been a way for the artist or creator to have prevented the situation from happening in the first place, perhaps protecting that idea before presenting it? And finally, do you agree with the final decision that there was in fact a breach of implied in fact contract, and why? Thank you so much, and here are my references.